some responsibility. Bank, today morning I contacted the MD. He said, you will agree with that, sir, there may be a court order. I told him, you send me a letter to that effect. I will place it, I will argue the matter. I will keep the letter as a material for my protection, not otherwise. I don't want to implicate in problem.
If the bank is agreeable for this offer, why the bank is not issuing any letter?
If they are issuing a letter, I want an instruction in writing from the bank, not to the court. Your Lordship may kindly pass an order by the court order, my lord, they will comply that. Because the problem with the bank is they have to answer for all the members during the general body. They may make so many comments, and the bank audit would also comes into the problem. That's the reason they want, there may be a court order. Based on the court order, we will make the payment without any further bargain. It is their instruction. I want those words in express letter to me. Keeping that letter, I will make a mention. Otherwise, my lord, if my learner friend is not inclined to accept, I will argue the matter, have this matter tomorrow, I will argue the matter. No issues at all.
Yes, sir, learned counsel, Mr. Mukannappa, is expressing his apprehension regarding the execution of that order. Again, there may be some...
Suppose if your lordship direct me to make a first payment on particular date, if I fail, can I not file a contempt and recover that money, my lord? Is it a difficulty for him, my lord? Is the court order could not be executed?
Kindly use the mic, Mr. Yes.
It's greatly experienced. Everything has to be done on the day. The settlement is money. It is not about
if both of you are not ready, then we list the matter for tomorrow. Yes.
Yes, tomorrow it could be, my lord, I will argue the matter. Or may I request your lordship to day after tomorrow, Wednesday, my lord?
Yeah. Release the matter on at the request of the learned counsel appearing for the parties.
Wednesday, my lord?
Yes, Wednesday only.
I am grateful.
Here also, Mr. Senior Counsel, Mr. Rajagopal, sir.
In all the matters, 182, 183, 184 common, all the three.
All the three. Yes. Yes. Even in this, Ratan Basavaraju is.
That is item number 7, is passed over.
No. Item number 21, we were appearing for R4.
21.
This matter to be heard, my lord, Mr. Veerbhadraya will be there.
Yes, I appear for the contesting respondent.
Yes.
Let's
argue the matter. Both of you are ready?
let's insofar as this matter, may I make one submission, my lord?
Yes.
My learned friend who has sought for Lord's filed this appeal against the order of the learned single judge who has dismissed the writ petition, basically seeking for Lord's the seniority. He has retired last year, and therefore, Lord's the cause of action itself is not available. Therefore, Lord's number of times the matter was adjourned for my learned friend to satisfy the court that the matter survives. So, could your lordship?
You are appearing for whom, sir?
I am appearing for the respondent against whom Lord's appeal is filed. Respond number 3.
In the first matter, 3 is the Institute of Nephrology.
It's writ appeal 78 of 2021.
Yes. The representing whom, sir, when a senior counsel?
Which I am appearing for respond number 3. I'm sorry, respond number 4.
4 is Mr. Dr. R. Keshamurthy.
Yes, my lords, I am appearing for Mr. Keshamurthy's
Your instructing counsel is Mr. H.N. Basavaraju, na?
Yes, no, it's my lord.
Veerabhadra. Let's may I make this submission, my lords?
First, it should be very clear, sir. That is, Mr. Veerabhadraya is appearing in the writ appeal 556 of 20, the appellant. Here in the first matter, respondent number 4, Dr. R. Keshamurthy, in the cause list is represented by Mr. H.N. Basavaraju.
I'm sorry, let's I stand
ma'am.
corrected. I stand corrected.
My senior is representing me, my lord.
Yes.
You will have satisfied these words, my lord, from one years.
Yes.
With regard to the seniority of practice, senior counsel is not there is no problem.
Kindly use the mic.
I'm sorry. There is no point in this act. And is retired these words. Retired these words, so the question these words of seniority will not survive consideration and hands of my lords. Please thanks to be appreciated the answers my lords are. The perversity, illegality, please will not in the judge. Not in please will not see the order has already honorable aid. That please will not say something, will not see this, will not say something. Second aspect of please. Please not. I am also eligible not to be appointed as the director of the institute. But I only submission means currently consider 22. I am not saying appointment. Qualifications. Otherwise, available today.
No, when you got retired? When you got retired?
I got retired only last year. But the age of directorship is not 70 years. So therefore, please note there is no bar please note to the state to appoint me please note to the director as of today. The age of
even after retirement, you can be appointed.
I can be appointed to the age of retirement. I am retired as a professor. My submission is as the senior most professor. I should have been the recommendation please note the consideration of appointment as the director. The tendency please note of the director.
Director of?
Please note.
Director.
University Institute. Submission to my lord is
Institute of Nephrology. So what is the age retirement age for the director of 70 years?
Yes.
So even after your retirement, you can be.
It is accepted. It is under consideration by the governing council of the society.
Yes. Now, what is the order of the London single judge?
The adoption of the institute. He was misconduct. He was terminated from services, but his termination was not required. Simply demanding these works the government 10 years accepted the resignation 10 years to resign. Class 1 is not the case of 6 years old. But if you are terminated from services in first instance, it is a bar is not a subsequent employment. It is a disqualification. But he suppresses this information after the he gets not appointed. Then after what the government assesses, what service not in the common work pass. That application is also not one of the services are terminated. Singling out is not 10 years reported to effect. That's a resignation not accepted. Thereafter is not all these malpractices are suppressed. Not he not adopted to the respondent of the whole institute. He must continue his work as an account director. The only case of political consequences from year 2014 till today. Not I believe that I'm a senior most person. My professorship is not more than 20 years. His professorship is not only 12 years. Consider me also, he is not for the post of director. When you consider when applications are made, please consider my name also is not.
So next to file
By imposing costs of 8,000.
2021. This writ appeal 556 of 2021 is filed by whom?
And the other aspect, what happened was, during the year 2019, on 29/12/2019, there was an annual general body meeting of the society. The society decided on the Society's Registration Act. Now, it is very, very clear.
No, it is filed by the same person, Dr. Keshav Murthy.
And the
In one case, Mr. Keshav Murthy is represented by the learned senior counsel. No. First, in the first matter, Dr. Keshav Murthy is represented by the learned senior counsel, Mr. M.R. Rajagopal. In the other matter, he is represented by another senior counsel.
That is their understanding.
The writ appeal 78 of 2021, Keshav Murthy is represented by senior counsel Mr. M.R. Nayak. In 556 of 2021, it's a writ appeal filed by Dr. Keshav Murthy, where I am appearing for Mr. Keshav Murthy in that writ appeal. There is one more writ appeal is filed, that is writ appeal number 625 of 2021. It is filed by the institution. It is represented by the institution advocate Prakash. There are two writ appeals arising out of the order passed by the learned single judge, that is 2021. Writ appeal 78 of 2021, where the learned senior counsel Mr. M.R. Nayak is appearing for Keshav Murthy.
It's an independent writ appeal, my lord.
Yes, it's an independent writ appeal.
With the other two matters. In the first matter in which, my lords, I am representing Mr. Keshav Murthy, arises out of, my lords, an order of the learned single judge who has dismissed the petition filed by the appellant herein, pointing out that A, there is an enormous delay, B, you can't seek for such a relief at this point of time, C, thereafter, my lords, he has retired from the service. The prayers which have been made in the writ petition were for setting aside the absorption order, my lords, of all the doctors in the Institute of Nephrology from the Bangalore Medical College. Now, thereafter, my lords, he sought for considering his case for appointment as a director. That he gave it up before the learned single judge and agitated it by way of a separate writ petition, which he has not pursued. Because he filed a memo saying that I am pursuing it in another proceedings. The only issue which, my lords, requires to be considered in this writ appeal is whether the order of absorption made in 2008, 4 years prior to his appointment, would survive. The second aspect is it has become infructuous now because he has himself retired. For somebody else's benefit, he can't be fighting out this petition merely on the ground that he has a right to be considered as for the directorship. That's a unrelated issue as against the main prayer, my lords, in the writ petition. If he is entitled to that, he can independently agitate that matter. That has nothing to do with this. Only if he succeeds in declaring that absorption is bad, then a right arises for him to consider, but even that doesn't arise because he has been reappointed on contract basis. This has nothing to do with the service issues which, my lords, arose before the learned single judge. Therefore, Successively, my lords, the division benches were adjourning this to hear on the maintainability of this writ appeal.
Mike.
And gain methodology these words and that being the fact these words, my thesis required. Already these words I was serving as a professor, these words in these words for almost 14 years. These words, 2004, these words, this is confirmed. But as per the original, not like the CA code these words. It's a prove the seniority. He placed me before he placed words himself, he purchased himself to harm me. Putting these words over down.
No, this writ petition was filed again challenging which
My
order?
seniority, my appointment is not of the administration as the director, and the adoption that is, this is not with us. But we are getting too much. 2014 is too much. Director. State Department Reserve is not even to neglect my seniority. I thought director is not free today. The post of director is not only 4 years. 2004. Based on these three case words, the contention case words, and the further contention that he is a terminated employee of the state. Surfacing
You argue your case, sir.
that is my case itself. I have challenged these words in adoption. Adoption, I have challenged these words into these words is a terminated employee. Suppressing the order of termination, these words he says indicates a second round of employment. After taking the second round of employment, he is not to refer to the effect of tenure because his resignation is accepted by the state. Therefore, these words I am on this ground. And the third one is the direction of the KD. He approaches the KD. The KD issues certain directions. We might be the matter simply.
That's all your argument, sir.
But we want to develop the judgment. Considering the rival contentions, case number 58 numbers these words. Yes, subject is good, paragraph number 18, third line of the part.
Para number? Para 30.
Internal
70.
Internal page is 41.
Internal page?
Internal page will be 18 months.
41. 41. Yes. Where is? In this set, no page in it. Yes. Set.
means it cannot be a ground for the
ಎಷ್ಟು 21
Officer, find out whether the learned senior and Mr. Subbarao ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಮ್ಯೂಟ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಎಸ್
and the next page is this paragraph being words are appreciate the the point of this is not okay. And the proceedings initiated against the initiated for non-compliance with justice and national justice and the can be directed to offer an opportunity to people this is about the game. Otherwise, they do not respond to the not approach the game. That being the factor of the legal position, having the senior counsel appearing for the petition to respond to not a dismissed employee and was disqualified for future employment in the government. Green light and carry the weight of the otherwise safe and on this point, yet the fact remains that the employee initiative is responsible dispute the initial appointment and induction of respondent number 4 into the service of the respondent number 2. May I pause for a moment? So this is the final is my submission is instead of the conclusion, the further conclusion urged by the minister that is the court respondent is legal submission and is not qualified for any employment in your 2 PCS 6 years rules cannot. How much is regarding the second prayer is that it is a yes. This is accepted in the year 2007. Execution pillars in the process. They submitted. It cannot be perspective. Coming to the legality of the acceptance of the resignation trigger by respondent number 4 is concerned, the material record revealed that the person with the orders of the Karnataka respondent was not submitted as a resignation on 2/2003 from 1/11/1994. His resignation is tendered with launch on 2/5/2003 accepted with effect from 1/11/1994, 11 years. That was the submission. There cannot be any more proposition of law that the authority to accept the resignation cannot be operated from a date earlier than the one on which the official resignation. But in the instant case, the petitioner has not challenged this order either before the statutory authority or before this court. My submission is resignation, acceptance of resignation is itself illegal. But I cannot challenge it because that is done by the state. One of these notes an entire. My submission to the law, I could not have challenged that. I could not because of the illegality it is not acceptance of resignation. Next time, undisputed resignation submitted by respondent to the court was accepted by the government by its order dated from the petitioner. Not to get rid of the petitioner who agreed with the action of the respondent, who today because the limit to the but it is settled in the law that even
Andram, phone ಮಾಡಿ ರೀಚ್ ಆಗುವಾಗ ನಿಮಗೆ ಮೆಸೇಜ್ ಕಳಿಸ್ಲಿಕ್ಕೆ.
especially in section 15 of the Administrative Act, refers to jurisdiction and authority. With regard to the appointment and recruitment of section 2 and the respondent to what these laws are implies these laws of the society. So therefore, these laws they not only need to be section 15 of the Administrative Act, but the writ jurisdiction to the only laws available remaining.
Now, what was the prior in the writ petition? Let us see the prior in the writ petition. It is absorption of the
Absorption only will not have challenge. So therefore, my submission is it is maintainable. I should not have to relate to the game.
the learned single judge has said, what is the opinion of the learned single judge? It is not maintainable.
Not maintainable is one aspect. On the factor based words of absorption, the learned single judge says section 15 challenge. For a declaration, submission to my words. No. These words is not the most services are merged with the methodology. I only challenge these words the absorption because these words is very important to state the product and demonstrate this support not is not connection is not the repetition. If the application is not yeah, is not police that not even involved in the application. Seniority is not being considered, and therefore so connection is not contact is not connection is not storage. It is not advertisement. I appreciate the advertisement of professor of nephrology.
Yes.
So here what happens is, for a person that should be appointed to the professor, he must have been declared as such university, the MCI. But I have 10 years, 15 years, 12 years, service. But recognized by MCI. Thereafter, we do not have been nominated as a professor. The post that was called for was not for a professor. If only these words are satisfied with the terms and conditions which were made for appointment as a professor, that's a good consider. It is not that I have been already not working as a professor.
Yes.
This is the list, please not to challenge. Serial number 4. This is serial number 3. Now what it does is, though these Mullard have been a professor in Mullard in year 2004, Mullard in another institute, my name in the date of appointment as a professor in Mullard is written in Mullard as 31/5/2012. I think it's not the time. Receiving this date. I can appreciate the this is the seniority.
So according to what is your entry of service?
My entry of service is 2012. But my appointment is the professor and head. That is the first time appointment. And preceding this month, they have already gone this month on another seniority list. Where my name is shown above all these people. Next page. In the director himself through the seniority list, but I was placed below. As per the bylaws, my respectful submission is not the director, is not it is the CMO is not of the association or the society, not to the seniority list. Point out. Number these are not undisputed tribal conditions. But the CMO could have to have a counseling and is drawn by the director. The contrary is not to the clients of the society. So it's very appreciated number 125. This is the second time. This is show cause notice that
Annexure?
Annexure E, CH-3, I'm sorry. This is the first appointment of number 101. The article of charge, that is great, is not again the respondent to the court application. Another copy is not appearing number 114 and 18. The new Dr. R. the assistant surgeon, body medical control, and departed on study leave for a period of 2 years from Karnataka. The sick leave was not sanctioned. Despite the sick leave was not sanctioned, unauthorized leave. And nurse 5 lines from their nurse, need nurse of the said rules. This is CCA rules. What it prescribes is, if a person takes nurse is under unauthorized absence for 4 months, his services will have to be necessarily terminated preceding an inquiry. That is all. Next, please. Because of this have been framed. The inquiry report is page number 148. That is the inquiry report. Not at the next page, please, not 115. But the designing is not for having accepted charges, but the inquiry officer in the paragraph number 3, which is very stated to be very clear as is not. The charges against the government, the following reasons are so arrived. As per the letter of superintendent Royal Medical Hospital, the assistant surgeon has submitted in 1995. With an intention to pursue the higher studies in consulting without submitting the main action unauthorized from 1/11/1994. That's his name was not sanctioned. But he did not inquire these months, he was sanctioned apart, and thereafter these months, and it's a clear these months, for 45 doctors these months, 46 doctors these months, I think 7 and exercise the powers under the A of the KCR, CCR rules, and Dr. Keshav Murthy these months, one among the terminated employees. My respectful submission these months is the services these months are terminated, preceded by a departmental inquiry.
Yes.
Great against these months are proven and established. He has taken part these months in the inquiry. Thereafter, these months he remains absent. It is not only against him, please not against 46 of government serving officers, please not the said action has been initiated. But my legal submission is, he being terminated by clause 8 only is not. That is not an order of termination, is a disqualification. Now what happens is,
This is for the post, they are the government service.
he was terminated as an employee. Based on 77. Termination of order. The clients and relying upon this, we are insisting on this, we are not starting on this age. The learning thing that they are doing not in this, most people are is not a problem. Can you appreciate this? Clearly, medical officer mentioned dismissed from the case with immediate effect. Therefore, please not my humble and respectful submission is not seen as being terminated and dismissed from the case. Please not a follow-up. Here, please not kindly appreciate these words. The crucial aspect here. This is when the learned signatures fell into error that time. This guy is justice. The subject please words at page number 180. There is a reference.
Yes.
Reference reads as such. The question referred to a larger bench is whether the ratio decided in Dr. Jayapal's case is reported in 15 years until 1988 by reconsideration. Larger bench case words did not words quite what with the point the facilitation. The only point of facilitation is whether the failure of the part of the lead sanction in the past orders of the leave application initiate the inquiry rule 6 years these are three. If a person is absent unauthorized for 4 months, but only preceded by an inquiry, he must be terminated. There is no other option from the state. What is the 168 is expected.
Yes.
The government servant who absents itself to duty without leave will not be able to reason the days and absence and period of such absence can be directed to the state account as though it were half paid leave to the extent such leave is due and extraordinary leave to the extent the period of such absence unless leave is granted by a competent authority for the days of such absence. Absence without leave granted by a competent authority. Such no liable to disciplinary action except where the government establishes he goes away. Government doesn't accept it. It is the wisdom of the government that they accept the letter or not. The state did not accept it.
Then what happened in the before the case came?
Kindly appreciate the word number 2. Let's paragraph number 6. 6 of this complicated judgment. Only pertains to the reference remarks under Jayama's case. Exactly what the balancing is there. Voting in favor of the not with the this is the apparent of the case. The second paragraph, the answer is not from the reference. It is not pertaining, it is not to the case of Dr. Keshamurthy. Balancing is this. With regard to Dr. Keshamurthy, please, you know, kindly appreciate paragraph number 9.
Yes.
The other factual aspects related to application number 579 and 86 are considered in the order of the entire matter is before us. Here, birds will come in both sides on merit. Subject matter of any application to be disposed of within a short compass. From the record, we have not been able to find out regarding any made yourself copy of the inquiry officer's report to the applicant. Therefore, we do not following the research process also. The district court may endeavor to furnish inquiry officer's report. The paragraph and I use it for judgment. Therefore, in the next page, it is remanded. Last 3 lines. In the read paragraph number 9, the letter decided by the Supreme Court, the authorities are directed to serve a copy of the inquiry officer's report, and thereafter the applicant is directed to furnish his application. Explanation: if any within 8 weeks from the date of the disciplinary authority, after considering explanation, has total orders in account. Now, this order itself is not bad enough because of this reason. And we appreciate page number 174. The second
Over this order of the day.
and thereafter please not annexed page number 169.
Yes.
Eight is not non-representation is not something page number 198 is not in himself submitted on 25/6/1987. Please reinstate. 25/6/1997 is zone letter page number 198. Please reinstate. Next is not. This is the second round of appointment. This order of termination is there. It is not set aside by the next second round of appointment. Page number 203. The earlier appointment is not. The right says previous and present employment. A specialist in urology medical hospital from there 1997 period. 1997 is not staying in the whole is not the state because the resignation is accepted in the year 2003. This was not in 1991.
Yes.
So if you want to misled, he misled the KPSC and secured the second appointment. My humble submission to my lords is my humble submission to my lords is he was terminated, please notes, number 1, and please notes, his termination order is not set aside by the PAP.
No, after the remand, what happened before the disciplinary authority?
He straight away comes and submits a letter to the minister. The minister has to take number 2. In administrative matters, the minister has to that was his matters of resignation. Page number 239, he makes a representation to the minister. The minister writes to 239. Principal secretary needs to put up fight and accept his resignation. There is a clear
He resigned.
Yes.
He resigned.
He resigns. That is accepted. It is not 10-year retrospective effect. Therefore, what happens is each and second appointment gets validated.
So before the disciplinary authority passing the term in conflict with the order of the KAT, he resigned.
Yes. The authority did not even consider.
Ah.
The order of the house did not take. They have invented this kind of a mechanism, and this mechanism of accepting resignation is not needed only to them.
Yes.
Many Christian the doctors have been terminated these words in one common order. But the order accepting resignation is a case number 245. How is it explained in the preamble? It is hereby ordered by the government accepting the resignation of the patient. Borrowing lenders in hospital Bangalore to effect from 1/11/1994 and to go to the department to liberate any investment. Retrospective effect of accepting resignation is from 1/11/1994. 10 years retrospective effect is when the resignation should accept it. Therefore, these units, my respectful humble submission is not CSK brought these units on the PDC. Others, these units, he said nothing to the working in my part. Actually, towards the articles of association, these units, or the respondent institute, where these units prescribes these units, the appointment director. State number 271. The new bylaw is 7 years.
271.
271.
Yes.
Married. This pertains to my second prayer, where I can be appointed this month to the director. Appointment of director on the recommendation of the Governing Council, either by director.
No, 271 is something different here.
Is a internal paragraph 13 of the bylaws. In 271, that is annexed to yes. 213. Must look at the group 13.
Page 278.
Sorry, there response.
Appointment.
One under the director shall be by the government on recommendation of the Governing Council or on contract basis or taxation from among the provided that the government shall be appointed by the director shall be appointed by the government amongst professors in neurology or nephrology. Contract basis or shall be provided not exceeding made on the recommendation of the Governing Council. Postgraduate degree in technology or biology. Experience of 10 years in university and technology, as in the case of contract appointment, and age in minimum 50 years experience, minimum 50 years, superannuation at the age of 65. Now it is increased to 70 years. Therefore, this is and as the board cross the list of seniority, the board, it is the interpretation thing. To my argument, I have disputed with seniority. Now, what happens is, if there is a dispute is not surprised with regard to the seniority, there is an interpretation class is not in the bylaw. It says the Lord has to be director. It's not a number. Not place it before the the superannuation and the interpretation. The bylaw clearly says that the CAO is not to got the seniorities. I will come to that. I will demonstrate. This is what it is. This is the broader perspective. This is the case. Now let's. Representation of these units in the page number 507, where I made a representation of these units to the director with regard to my seniority.
No, in the bylaws, where do we get
I
OS?
will
Yes, sir.
the bylaws.
20. 20 is property and function.
This is the CAO.
23. Ah.
The seniority, in the case on hand, these units, it is the director who was repeatedly trying these units the list of seniority. These units, and subsequently the bylaw itself provides these units in case of a dispute that is raised by any officer these units of the organization. It will be referred to the governing council. Because I have a page number 507. Why is the dispute? It should have been kept before the governing council. These units not kept before the governing council. So yeah. I challenge the list of seniority itself. We have a merit also of these units. I will send R9 these units. The state has provided these provisions.
Page number?
507 additional R9 these units that is published by the state. Page number 786.
Is there in page 513 annexure R9?
Annexure R9 these
Ah.
units. That is my representation.
Ah.
Provide representation these units that has not been considered. Therefore, these units are involved in the alternate remedy, but to approach these units this one. Now, this is my analysis. And these units, we observe, is a entry these units to the service the second time. These units initiated because of this suppression of material factor as fraud.
You understood it?
Yes.
Yes.
Now let's the judgments are relevant. These are not I only take the notes to state this also will accept these units. Directed my case. We appointed these units for 3 months. The 3 months from the date of birth. I find another instruction, I will do it. For example, instead of the process of finding a new character has already been the rest of it as creates for is dismissed. Absorption is this order is created on 7th June 2021. 8 2021, the state has not initiated cases. Please do not see. Dr. Anil Bajaj's case, I could not case it for my heart. But I will case it towards. Only once the list of judgment case. These judgments are not given. When I read paragraph number 3, it will shortly. Same application take the position the principle of estoppel apart can be applicable in the case of namely of the sanction come back to the employer and if it does not come back, he will automatically be declared as being terminated. He then cannot further challenge the said condition on the basis. Suppose if there is a dispute with regard to the question that the declarer has in fact come back within the time it is strictly granted. An inquiry may be necessary, but when the facts are not it doesn't come back. Termination very long. In the middle class case. Middle class case, but with respect to effect of resignation, acceptance of resignation.
Yes.
Of the more cases, the appointing authority in respect of service or post and the here, however, the government service is only resignation is accepted. All that effect from the date following the resignation of the in respect of then count towards the rupees once the next time. Resignation in order to become effective. Whilst the consensus of the person delaying the resignation cannot be accepting that resignation, therefore, operator will effect on the date earlier than the one on which the official has tendered the resignation. The appointing authority may accept the resignation with immediate effect or with effect from prospective date. That is what has been avoided. Therefore, we are clearly of the opinion that the order of the first respondent accept the resignation of the petitioner from cannot be supported. Therefore, the 10-year retrospective effect the resignation has been accepted. This has been declared these months by important this judgment is not a recognized one. It is not the recent judgment is not on fraud. These marks I have demonstrated. He stated these marks he was in money. His services these marks have continued in these marks from the state.
Yes.
Indian of India was a name last year. Single class of fraudulent appointment. This is also writing for a judgment. Rightly express the following. The concerned source and employees is not considering have repeatedly snatched employment and release of its DD as well to DD of a casual basis by relying upon both the goals schedule. This topic is of disapplication and fraud perpetrated by any employed in revenue services and had snatched such appointment. Not having made available to them if they were not armed with such goals and goals.
Yes, we understood it.
Yes, this is the legal purpose. He has misrepresented these words in the second round of litigation. These words and the words clearly these words is a important. But when the name of these words are cited in the and not the original and what it is.
Bachitar Singh. Bachitar Singh versus State of Punjab. Yes. (1962) supplement 3 SCR. Yes. If the inquiry report is not given to the employee, show cause, yes, it is set, yes. No, in terms of Ramzan Khan and Karunakar case, it is mandatory. Yes, if it is not supplied, if it is inquiry report itself is not supplied to the delinquent employee, then whether that inquiry report is justifiable. Yes. Yes, that will not go into that. That is what the KT has observed. Yes. 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 No, we are not going to this departmental inquiry. So come to the next judgment. Yes. Yes. Yes.
Prior to that, there is a departmental inquiry. That is also a policy judicial.
Yes, yes.
Unless that is set aside, there cannot be a subsequent action.
Yes. Next judgment.
Cannot interfere with resignation. He says, you can consider persons. Making the appointment of respondent before that. Erroneous. This resulted in infringement of the rights to the applicant. My submission is, as on the day 2020 itself, my qualification, the requirement is not for consideration. Yes, it is not as the next case is the Oscar's case. It is the same words initiated by fraud. With regard to this, the order of the finding of the learned single judge, I do not have challenge in this proceedings. And I should have gone before KT and so on and so forth. Single order in fact is the 30 fees. Even collateral proceedings, what is brought, it can be challenged. What discipline of eligibility of education. We are constrained to say that more often than not, process of court is being those property that are accelerated and no hesitation in the person case is based on also has no right of summary to so my humble submission is this particular continuity affects fraud. Establish that even in collateral proceedings also, the fraud can be challenged. I appreciate page number 32 of this memo. That is the original singular. Department of Neurology. Procedure number 3 is procedure number 4 please. Or 5, they want it at. Then let's in the first case, 6, 7, subject of consideration please at the time of writing seniority. 6, 7, and 8. So with regard to Dr. Keshamurthy, Professor of Neurology, after MCA, period is 12 years. And Department of Neurology, Dr. Yellowish, which after MCA experience 17 years. These marks, I guess these marks more than these marks. Not original list. However, these marks, this column, where we have an MCA teaching, they have conjugated it these marks. Because when the Dr. Keshamurthy purchases it, possibly finalist, and he purchases himself a copy. Thereby, these marks, the 17 years experience that has been shown in the original list. That is okay. And the new list is this is what happens.
What is a tenure? Where do we get a tenure in the bylaw? Age limit minimum 50 years. Appointment of correct. But tenure of the director.
Appointment of contract cases, oral declaration shall be for a period not exceeding 5 years.
Not exceeding 5 years.
As things today,
So from 2014 he is continuing, huh?
there are several instances.
No, he is continuing, your submission is continuing from 2014.
Today.
Actually, 6 months he was, then there is a government, then he discharged, then the again he appointed discharge. Too much political.
So according to you, from when he is working as a director?
Each time, 1 month, 1 year, 1.5 years like that. 1 year, this time. From 2 years.
From last 2 years.
Yes.
2014.
No, sorry.
Yes, sir. Yes, sir. Yes. What is the next appeal?
Next step is what happens is.
No, let us see what is the next appeal. Huh? Amendment of appeal.
As pointed out,
Now it is, according to it is 70 years. No, we'll hear together. Yes. No, let him argue then. If it is his appeal, let him argue it. Yes. 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 Yes, let the senior counsel.
Let, yeah, Lordships are calling upon me to add him.
Oh, whoever the other counsel, Mr. Veerabhadraya, who is appearing for you, sir?
No, I'm not. Let's make one request.
But it is for the same respondent, two learned senior counsels are.
There's some confusion, my lords. May I just respond to your lordship's question?
No, in the first respondent, who is representing the fourth respondent?
I'm appearing, my lords, for number.
You are senior. Yes, yes, sir.
Which I'm appearing in the first matter for respond number 4,
Yes, sir.
which have nothing to do with the other 2 writ appeals.
Yes, sir.
I'll presently point out. So therefore, your lordship may permit me to respond to my learned friend's argument in the first matter.
Yes, sir.
Yes. Well, let's have filed a note of submissions. Could your lords kindly take it up so that I don't waste your lordship's time, lords, going into, because my learned friend mixed up several issues, my lords, in arguing his case. May I request my lords to kindly take a brief note of submissions, my lords, which was filed by me on 7/9/2021.
You file it in writ appeal 78 or in the other writ appeal, sir?
Only in 78.
78.
Yes.
What is the date?
It's Mr. Veerabhadra is there in the court. Probably he will assist the court in identifying my submissions.
Not available here. Yes, sir.
Yes. Let's, before I take your lordships through this submission, may I request my lords to kindly take the prayer made in the writ petition, which my lord will find at page 106. Page 106, my lords, of the writ appeal proceedings.
Sir,
My lord has that, my lord?
we are at page 106.
Let's, that is internal page 26 of the writ petition, my lords, which
Yes,
is
sir.
meant for the writ appeal proceedings. Prayer
Sir,
column.
we are in the prayer column only. We are there.
Yes, my lords. The first prayer is to quash the absorption. I will not trouble
Yes.
reading all this. I'm just mentioning it, drawing your lordships' attention. The first prayer is to quash the absorption.
Yes.
The second prayer is to quash the notification pertaining to seniority list.
Yes.
The third prayer is, my lords, to quash the placing of the fourth respondent as additional charge of the post of director. And the fourth one is to grant all consequential benefits, including seniority, to the petitioner and place him above fourth respondent and appoint him as director. These are the four prayers, my lords, which has been made. Now, my lords, prayer C and D were given up before the learned single judge, pointing out that a separate writ petition has been filed and those issues arise therein, and therefore the prayers in this are not pressed in this writ petition. Now, having taken note of, my lords, I would like to draw your lordship's attention to the issues which were raised based on the pleadings of the parties, which my lord will find in para 16 of the order of the learned single judge, which is at page 56.
Yes.
I'll just read it for the purpose of completion of my submission. Para 16, I have bestowed my careful consideration to the multi-pronged contentions urged by the parties and have carefully scrutinized the material on record. In the light of the above contentions, the points that arise for consideration are: 1. Whether respondent number 4 was disqualified for future employment in the service of the state in view of his alleged dismissal from service in the Department of Health and Family Welfare. Whether the acceptance of resignation of respondent number 4 by the state government with the retrospective effect is bad in law. Whether the absorption of respondent 4 in the Institute of Nephrology is violative of bylaws of the institute. Whether the petitioner is entitled for the relief claimed in the petition without seeking the relief of quashment of initial appointment of respondent 4 as a lecturer in 2000 and acceptance of his resignation by the government in 2003, whether the petitioner has locus standi to challenge the absorption and consequent seniority of respondent 4 under Article 226 of the Constitution, whether the seniority list prepared by the second respondent is in accordance with rules and regulations governing the second respondent institute, whether the notification dated 27/8 placing the fourth respondent in additional charge of the director suffers from any illegality and contravention of the bylaws of the institution. These were the 7 issues, my lords, which were raised before the learned single judge. May I request my lords to kindly come to page 76, because I want to point out that they were given up and does not arise in this writ appeal. Page 76. Para 31.
Para 31.
Yes, my lords. In view of the, Lord has that, my lords, at page 76, internal page 59 of the judgment. In view of the above conclusion, point number 4 and 5 do not survive for consideration. even if it is held that the petitioner has locus standi to challenge the absorption and the consequent seniority of respondent number 4, yet in view of my finding that the absorption of respondent number 4 is in accordance with law and the rules and regulations governing respondent number 3 institute, it has to be held that the petitioner is not entitled for the relief A claimed in the petition. The claim made by the petitioner for restoration of his seniority and his entitlement eligibility for post of director are elaborately discussed in my by me in the final order pronounced today in writ petition 7141 of 2020, and I have held that the seniority list prepared by the respondent number 3 is in accordance with rules and regulations governing respondent number 3 institute, and that the petitioner is precluded from disputing the said seniority list as he was not even born in the cadre when for
There was some interruption by any other by some other learned counsel. We request all the learned counsels not to interfere during the proceedings.
Yes,
Kindly mute your systems other than the learned counsels who are arguing the matter.
let's say on page 77, the concluding part of it, that the petitioner is precluded from disputing the said seniority list as he was not even born in the cadre when respondent number 4 was appointed as professor. In the same order, I have upheld the ad hoc appointment of the fourth respondent as in charge.
Krishnamurthy, Mr. E. Krishnamurthy, you are disturbing the proceedings.
Senior counsel, I think your client has logged in.
I think the court officer can mute the proceedings modes other than this case so that it doesn't disturb the court's proceedings.
Maybe the respondent number 4 here, Mr. Krishnamurthy.
No.
Huh?
That is Dr. Keshav Murthy is respondent number 4. And he has no business to be logging in these proceedings and interrupt the court.
Maybe kindly don't disturb the proceedings.
There's just one more sentence at page 77.
Yes.
In the said order, I have upheld the ad hoc appointment of fourth respondent as in charge director. As a result, relief number B and C claimed in the petition are also liable to be rejected. Point number 6 and 7 are accordingly answered against the petitioner. So, and he proceeds to dismiss this petition. That's the reason why I'm drawing your lordship's attention to this order of the learned single judge with reference to writ petition 7141 of 2020 is that in that writ petition, the petitioner separately sought for setting aside the appointment of the in charge director and the seniority. The learned single judge elaborately considered those issues, Milords, in that writ petition. A writ appeal was filed, Milords, as writ appeal 6 of 2020-21, and that writ appeal has been dismissed.
Writ appeal 6 of
2020-21.
Where is that order of this court dismissing the writ appeal?
I will request Mr. Veerbhadraya to place it on record. I don't think my learned friend is disputing that fact of dismissal of those appeals. Otherwise, they were all clubbed together and not placed, my lords, before your lordships.
Kindly.
Having
You read it? Yes.
Lords, having pointed
Yes.
out that, my lords, may I request your lordships to kindly come back to page 40, my lords, after I pointed out the various issues that arise for consideration. Para 17 is relevant for my purpose, my lords, which is at page 57.
Because pagination is not here for this judgment. Para
Internal internal page 40 of the order of the learned single judge.
Page is not here, sir. For the page duration is not given in the first set.
No, in the writ appeal, notes, the impugned order against which this appeal is filed is the very first document, my lords, which at page 40 of that order of the learned single judge, the para 17 is available. Lords, this is the pagination which my learned friend has given, therefore I am proceeding on that.
Kindly read it, sir. We got it. Kindly read it.
Yes, at the outset, it is to be noted that the petitioner has not challenged the selection and appointment of respondent number 4 as a lecturer in Bangalore Medical College. However, having realized that without setting aside the initial appointment of respondent number 4, the petitioner cannot sustain his challenge to the absorption and subsequent posting of respondent number 4 as in charge director of respondent number 3 institute. An indirect challenge is mounted against respondent number 4, challenging his entry into the service of respondent number 2 on the ground that the dismissal order passed against respondent number 4 by respondent number 2 was neither set aside nor was he reinstated in service by the Karnataka Administrative Tribunal, and therefore he, being a dismissed employee, was not entitled for future employment in the government, and consequently his induction into the respondent number 3 institute is illegal and contrary to rules and regulations of the institute, which my learned friend is trying to place reliance on this argument of his, lords, in this writ appeal. Lords, para 18. This argument, in my view, is wholly misconceived and proceeds on the erroneous reading of order of the Karnataka Administrative Tribunal in application number so and so. I have gone through this order passed by the Karnataka Administrative Tribunal, which is at serial annexure 13. No doubt, as contended by learned senior counsel for the petitioner, the said order does not state in so many words that the order of dismissal passed against the 4th respondent is set aside, nor is there any direction to reinstate respondent number 3, but that by itself cannot be a ground for the petitioner to brand respondent number 4 as a dismissed employee. The petitioner does not dispute the fact that respondent number 4 had challenged his dismissal order, and the matter was finally decided by the KAT by its order dated 4/4/1997. A bare reading of the above order indicates that the question as to whether the failure on the part of the leave sanctioning authority to pass orders on the leave application submitted by the employee vitiates the inquiry and was referred for consideration of the larger bench. Answering this question, the Honorable KAT in para 5 of the order has observed thus, which has gone into the aspect of consideration. Then, my lords, at page 43, para 9, in the light of having arrived at the above conclusion, the tribunal in the concluding para of the judgment has ordered thus. In the light of the above ratio of case decided by the Supreme Court, the authorities are directed to serve the copy of the inquiry officer's report, and thereafter the applicant is directed to furnish his explanation, if any, within 8 weeks from the date of receipt of inquiry officer's report. The disciplinary authority, after considering the explanation, pass suitable orders in accordance with law. This order of the KAT is being characterized by my learned friend as saying that having not quashed the order of dismissal, but merely having said you will reconsider my dismissal order, amounts to not setting aside, and therefore it remains on record, and therefore it could not have been taken out of by the government appears to be his submission. Which is on the face of it is an erroneous assumption, because I filed my reply to the show cause notice which was issued based on Ramjan Khan's principle. The government took note of my submission, and then, lords, it accepted my resignation in the meantime, not seeking to proceed with the inquiry which it had initiated. That surely can be questioned if, my lord, somebody is aggrieved by a process known to law, which, my lords, the learned single judge has discussed in para 20 onwards, by way of filing an application before the KAT if he is aggrieved. But what the learned single judge has recorded is that having entered the service in 2012, you can't go on questioning what was what has happened in 2000 and 2003, which he is characterizing it as illegal by the governmental authorities, and therefore the learned single judge holds there is no locus standi. It also says, since the government accepted the resignation, question of further proceeding the disciplinary proceedings doesn't arise. That surely can't be found fault with in this manner by my learned friend who was not even in service. That's why the learned judge says he was not even born in the service, and therefore without invoking the jurisdictional authority to question even if he is aggrieved, can't be entertained after so many years, after 15 years. In these writ proceedings is the reasoning recorded. I don't find anything wrong, Lords, in the reasoning adopted by the learned single judge. Lords, at para 20, the reasonings have been pointed out, Lords, by the learned single judge. May I just read that para 20, Lords?
Yeah, read it, sir.
Yes, Lords, if your Lords have read it, Lords.
Open and read.
Learned single judge records a finding that you can't characterize him as a dismissed employee because in furtherance of the remand order, no final order was made by the government. And in the meantime, Lords, my resignation came to be accepted and I was appointed independently, Lords, as a lecturer in the Bangalore Medical College. So therefore, in his desperation, in order to non-suit me, Lords, he raised this issue, which the learned single judge has considered and decided under point number 1 and 2. Let's point number 2 at his internal page 46.
Yes, because he has not challenged it.
Yes.
The acceptance of the resignation with retrospective effect before the statutory authorities or before the court.
Challenge, if you had the locus, if you were to challenge within the time frame, then it would have been a different matter.
Yes.
Now, the learned single judge records a finding that this indirect method of challenging what had happened 15 years back cannot be countenanced is the reasoning recorded in notes under point number 2. Let's page para 22. Para 22 at internal page 47. Undisputedly, the resignation submitted by respondent number 4 was accepted by the government by its order dated 8/7. Though the learned senior counsel for the petitioner has sought to contend that in order to get rid of weed, the petitioner is aggrieved by the action of respondent could take recourse to eliminate the root. But it is settled proposition of law that even if the order is void or illegal, it requires to be declared so by a competent forum, and it is not permissible for any person to challenge the validity of the said order in a collateral proceedings. This is the reasoning adopted. It goes into several position in law as to whether he could bypass the competent authority, namely the KAT. And Lord said, para 46, para 26 at internal page 51. The argument, Lords, is met by the learned single judge recording this finding, which I am sure, Lords, cannot be found fault with in this writ appeal. Para 26, internal page 51. In the light of the above proposition of law, the arguments advanced by learned senior counsel for the petitioner and learned counsel for third respondent that the respondent number 2 has misled the government by showing a wrong date of his entry into service in the application form and antedated the resignation letter do not merit consideration. Even otherwise, the contention raised by the petitioner in this regard are based on disputed facts which cannot be adjudicated by this court under 226 of the Constitution, especially when Section 15 of the Administrative Tribunal Act confers jurisdiction and authority on the Administrative Tribunal to adjudicate any dispute with regard to appointment and recruitment of the civil service. Thus, Lords, after extracting the provisions of KAT, the court records a finding at para 27, page 53. Thus, this statute having provided specific remedies for redressal of the dispute and matters relatable to the service under the state, this court cannot adjudicate the said issue on the guise of deciding the seniority of respondent number 4 in collateral proceedings. As a result, I hold that the dispute raised by the petitioner challenging the acceptance of resignation by the government is legally untenable and liable to be dismissed. Then, my lords, point number 3 is the issue of absorption of respond number 4. Now, let's the contention that was raised by my learned friend was that under the bylaws of this society, that is Milord's Institute of Nephrology, there is a need for the governing council to approve the absorption, and therefore it was in the teeth of the bylaws is the argument. I will not trouble reading this, but that's the contention. The learned single judge records a finding that the appointment under the bylaws is altogether different. This was a case of the government shifting the entirety of the nephrology department in Bangalore Medical College to the Institute of the Nephrology by a GO, which is permissible in law, and therefore you cannot say it is not after approval by the governing council. But insofar as governing council is concerned, it has been entrusted under the bylaw to have an approval of the employees who are appointed under the bylaws and by the board of governors. This has nothing to do with that. That's the reasoning, my lords, which is recorded by the learned single judge in point number 3. Lords, if necessary, I'll read it, but I'm sure my learned friend has pointed out this aspect, my lords, in his argument. It completely relies upon the bylaws, which the learned single judge says has nothing, no bearing on the issue, and therefore that argument is rejected. Notice the conclusion is at para 30 at internal page 58 of the judgment, para 30. In this context, it may also be relevant to note that as per Rule 9(3)(g) of the Rules and Regulations of the Institute of Nephrology, among other things, the governing shall have the power to create posts and to make appointments thereto in accordance with provisions of Rule 16 to 18. Thus, there is a clear distinction between the posts transferred from Bangalore Medical College to INU under the government order dated 1/9/2003 and posts created by governing council. It is only the post created by governing council whose appointment is required to be done approved by the governing council. For the purpose of absorption of the staff of the government servants from other departments, the rules only provide for approval of the screening committee to be constituted by the governing council. In the instant case, Annexure 24 produced by respondent number 4 indicates that the screening committee in its meeting held on 6/3 for absorption of government servants into service of Institute of Nephrology has taken up the process of absorption and directed to obtain options of the permanent absorption. Accordingly, the option was submitted by the fourth respondent. On considering the same, the screening committee in its proceedings dated 6/3 has accorded approval, and accordingly the absorption order was passed by the government order dated 29/11/2008. As such, there is no illegality whatsoever in the absorption of respondent 4 as sought to be contended by the petitioner. This is the issue, my lords, which has been decided by the learned single judge, pointing out the fallacy in the argument of the petitioner that in the absence of an approval by the governing council, this absorption is bad. Now, consequently, he raises an issue that his seniority, which is recorded by the authorities in terms of, let's page 118, lots is a seniority list, which he characterizes as bad in law, which is other prayer, lots, which he is trying to press, saying that he is senior to Dr. Keshavamurthy and therefore his appointment should have been made. This issue, my lords, incidentally has been considered by the learned single judge by a separate elaborate order, my lords, in the other writ petition, which was subject matter of writ appeal 6, my lords, which has stood dismissed. However, my lords, one of the ground which my learned friend is pressing into service is that he had rendered certain service in Ramaya Medical College before his appointment in 2012. So that experience should be counted for the purpose of his seniority, which is a misconception. Service rendered in a private college can never be counted for the purpose of seniority merely because his grievance is that they should have invited application immediately when he was eligible. The delay in appointing him in 2012 can't be held against him to deny him his experience in Ramaya Medical College for the purpose of consideration of seniority, which not the learned single judge is rejected by consideration notes, not only in para 31 but also by an elaborate judgment in writ petition notes, which I mentioned, that is notes in which against which notes the writ appeal, writ petition 7141 of 2020, which was dismissed, has considered that aspect. Therefore, notes the entirety of my learned friend's grievance is misconceived. The second aspect is, notes, he retired in April 2021. He is trying to press for consideration of this appeal, though it has become unnecessary and infructuous. On the
When he retired in 2000?
April 2021.
Exact date?
The date of retirement is, I will check it up and give it. It is April 2021. I think probably Mr.
April 2021.
Yes, probably Mr. Veerabhadraya asked him to see the exact date and then make a submission to the court. So what is important for my purpose is that he is trying to keep this issue alive by contending that he is entitled to consideration for the post of director. Look, entirety of this litigation before your lordships as well as before the learned single judges in regard to the appointment as a ad hoc director. So all submissions which my learned friend tried to make with reference to bylaws not entitled to more than 5 years, all that do not apply to the in charge director. This position has been considered by the learned single judge in writ petition 7141 of 2020. And he has also incidentally directed the government to proceed with appointment of the director in accordance with the requirement under the bylaw. Now that is also being stalled. If my learned friend is entitled to consideration, despite the fact that he has retired and he has been appointed under a contract, that is a separate cause of action. He can't be agitating that in this. But
After his retirement, now he has been appointed on contract.
on contract basis, assuming, Lords, that he is entitled to as a contract employee for consideration of the post of director, which the learned single judge directed in the connected matter, that is Lords WP 714 of 2020, he can make an application there and ask it to be considered. He can't be mixing up the two issues and then pressing for seeking for continuation of these proceedings when he has retired. Both the prayers, namely of absorption and his seniority, have spent. For the same reason, Lords, the writ appeal 6 was not pursued by him. Therefore, Lords, this writ appeal in any case is a misconceived petition. It has become unnecessary because of his retirement. Now, he can't be saying, I have a possibility of being considered for the post of the director once Keshav Murthy is held to be, his absorption is bad because he would not qualify for the post of director, is an issue which would arise in future as and when such a thing happens. Let's kindly see the order made by the learned single judge as well as division bench in writ petition 7141 of 2020, the last portion of that judgment where there's a direction to the government to consider the proceed with
Where is the order of 7? No, that writ appeal order we have with us. But where is the order of the learned single judge?
Let's, the order of the learned single judge, my lords, would be in writ appeal 6 of 2021. It was being tagged along with this, but it got dismissed. So therefore, my lords, probably it is not immediately available. I'll request Mr. Veerbhadraya to request the registry to place that
Yes.
judgment. Or
Yes, sir.
probably he'll be able to hand over a copy of that judgment, my lords, since he has number of copies of those writ appeal proceedings.
Yes.
Let's, having not pursued the appointment of the director in terms of his prayer, my lords, in the connected matter, he can't be keeping this alive, this issue, which pertains to absorption of mind, my lords, in the department. The court says you can't do it under 226. You should have challenged it in the before the KIT, as and when such an illegality, even assuming it is an irregularity, took place. Now, surely, my lords, such a reasoning can't be found fault with in this writ appeal. My lords, I asked this question myself, assuming that his writ petition is allowed. How does that, my lords, inure to his benefit in an issue which may arise in future in regard to appointment of the director? My learned friend has not brought to your lordship's notice the fact that the entirety of this litigation, both this and WP 7141 of 2020, pertain to the appointment as an ad hoc director. This seniority, my lords, is to be taken note of in appointing an ad hoc director. The court, my lords, noticed that he is not senior and therefore he can't have a claim on the position of ad hoc director. Therefore, he gave up those issues, my lords, which had been raised in the subsequent petition filed by him only. Now it is for somebody else's benefit, probably he wants to keep this issue alive and pursue it for a declaration that my appointment in 2000 was irregular and therefore the absorption is bad. The absorption again is under a misconception, thinking that the board has not approved my absorption, which the learned single judge has recorded a finding that the absorption, the entirety of the department from Bangalore Medical College into this separate entity which was created by the government order itself can't be subject matter of an approval by an authority like a board of governors of this new institute which Milords had come. So therefore, Milords, the entire petition is misconceived. The appeal cannot be Milords, pursued at this point of time. Even otherwise, on merits, Milords, it's a well-reasoned order by the learned single judge, and therefore I pray, Milords, that this appeal be dismissed as wholly unnecessary at this point. Let's, in regard to the other two matters, am I audible, Milords?
Yes, yes.
The other two matters pertain to a challenge to the amendment to the bylaws, which had brought, Milords, the age of retirement of the director to 60, in line with, Milords, the retirement age of all the functionaries in the institution. That is a standard process, standard stipulation, Milords, by the government in all the independent autonomous bodies, Milords, created in the state, including the autonomous medical colleges. Now that was challenged by him. That, Milords, was amended, and he is asking for, Milords, questioning the amendment on the ground that there was a procedural irregularity by the registrar in approving it, against which, Milords, these proceedings have been initiated, which are subject matter of other two petitions where, Milords, the learned senior counsels will assist, Milords. It has absolutely nothing to do with the issue which is being debated in this 78 of 2021. So that's my humble submission.
Mike, who's the mic?
Age of parental eligibility.
Now we will, the learned senior counsel is submitting, the other learned senior counsel will argue. Yes. We will hear on that bylaw, amendment of bylaw. Yes, Minister Counsel. Yes. 240 is what is 240?
Thirty-seven.
47 years.
Correct.
Annexure, your pagination is not tallying with ours. Bylaws, number 20. Seniority. Yes.
The question do not arise at all for this reason, Lord. I request the Lord the two persons are appointed in the same day, the seniority between them shall be determined as follows. Very possible. The respondent appointed in the year 2000, appointed in the year 2012. The question of dispute arises and needs to place before the court only on the same day. Hence, this criteria is to go in.
It's appointed on the same date.
Yes, ma'am. Then is argued. Others.
Yes. But the seniority list prepared by the director. Here the CEO has to prepare the seniority list, but the seniority list was prepared by the director. Your answer. Okay.
Has amended the bylaw.
So this is regarding the amendment of bylaw. We'll come to that later. First, you will close this matter. Yes. Yes. Annex AC.
I will read the last paragraph. Sorry. Let us read fact 5. About that, by furnishing list of teachings, one exercise their option. For example, the Institute of Bangalore has requested the government the absorption and new government service. After careful examination of the matter in detail, the government has decided to offer sanction. Especially working with the Institute of Urology, Bangalore to the Autonomous Institute of Nephrology, Bangalore, and issued this order. The government are pleased to afford sanction in the interest of public service from the government absorption of medical education department presently working in the Institute of Nephrology, Bangalore, as mentioned below. The Autonomous Institute of Nephrology, Bangalore, with retrospective effect from the day on which the Institute of was established as autonomous institution subject to the following conditions. Here we go. At scene number 6, Dr. R. Keshav, Professor of Urology. He was the professor as the date of shifting on 8 itself. And the applicant has joined the institute as in 2012. Earlier he was working in private hospital. That experience we cannot consider for seniority. Hence, the contention on this note is to go with. And last below, the amendment was brought to the bylaw by reducing the age of appointment of director from 65 to 60, and that was approved by the district registrar. That was challenged by the applicant. The learned has remanded the matter back. After remanding, he has refused to amend the bylaw, approve the resolution. He has rejected. That was challenged by the institute before the Karnataka appeal. He appealed number 24 of 2020 consideration.
Now, the issue involved in this writ petition. And
Yes, it is that he attends supervision. The question of claiming cannot arise at the level. He has not decided. And he has attended supervision. He will know in the future. So, findings will not arise at the
according to him, he is now a contract employee.
contract assess only. Certainly that. Emergencies will be they call contract. temporary basis. Contract doctor he cannot, he doesn't have the right to ask to treat him as a regular employee.
Yes.
It's a time we age of superannuation. That's my solution. Hence, my question. Page number 73, the another single judge is out of order 6. Appointment was made or not created by the institute as intended to the commissioner that were existing in the other departments were transferred and absorbed into the institution at the time of establishment of the institute. This distinction was transferred by government and post to the institute. Indicate that the government had upon sanction the public interest for the permanent absorption of teaching staff of medical education department and working institute of meteorology. Bangalore to the Autonomous Institution of Meteorology. Bangalore with retrospective effect from the date on which the reported by the Institute of Meteorology. Subject to the conditions described therein. The name of the respondent number 4 finds case as it proceeds and this date of entry into service there is shown as 2000. This is very important. Yes, entered the service. When the applicant entered the service in the year 2001, as on that date, the petitioner hearing was not even brought in the service of the third respondent. The absorption of respondent number 4 as well as other similarly placed employees has been done by the government following the process as contemplated in these orders of the government, which are produced by the government agencies appearing from the respondent number 1 and 2. For instance, where the to procedure of absorption along with respondent number 4 to 7. Similarly, placed employees cannot be set at not on purported contention as the petitioner that the absorption of the 4th respondent was bad for want of previous approval of the government council. This is not correct. So the government council, the condition has to go because of this reason. Earlier, the government has transferred. Whenever the institute wants to appoint newly, after establishment, they don't get the question of taking concern and consider the government council. This is the question to dismiss the appeal.
Ah. 13, 4. Here, take this. 0. It is
when you are here 50 years, 7 months, and 17 days, contrary to the cable recruitment rules of the institution, which have stipulated the age of entry for the post officer for direct recruitment as 45 years for general cabinet. Even though the seniority list was published by the institution in 2013 and later in January 2015, the petitioner filed his objection to the provisional seniority list in 2015, requesting the institution to consider the submission private medical college vaccines for petitioner and family. Only on 31/5/2012, the services rendered by him elsewhere could not be considered. His objections were not valid for such reasons. The retirement of Dr. H. Nagaraj, respondent number 4 being the senior most teaching faculty, in exercise of powers vested with the government to appoint a director, he was put in additional charge only by way of interim management to the regular director was appointed. It is not a promotion but only vesting with an additional charge, and therefore they are made additional challenging appointment.
Now, how long can you put in the ad hoc charge as a temporary arrangement, interim arrangement? How long can you continue it? There is a direction by the division bench. What action you have taken, whether you have implemented that order. Order is dated 7th June 2021. There is a direction to appoint the regular director within a period of 3 months from the date of that order. Why you are not regular director? Why you are prolonging it like this?
The governing council consists of
Don't give reasons. If this has reached finality, the order passed in writ appeal number 6 of 2021. Is it not required for you to the regular director within a period of 3 months?
Let's make assist the court, my lords, on this question.
No, let the government advocate answer, sir. Let the
You
senior
probably
counsel.
is not aware of the developments which I want to place it before the court. The government,
What is the development?
in furtherance of this direction, government met. Government, my lords, has certain issues were raised about pendency of this writ appeal, and therefore, my lords, the government has called for a report on the pendency of these matters before the court. Otherwise, matter is seized by the government in appointing the director, my lords, of in terms of the division bench order. That's the factual aspect which I wanted to tell.
Where is any interim order of stay in the appointment of the regular directors, sir?
Therefore, the government proceeded. It met.
You can take undue advantage of the pendency of these matters before this court. There is no sense of any interim should not be appreciated.
It is under consideration. Notification based on this order, notification is consideration.
No. No, you would have appointed honor before September 19th, 7th September 2021. Now we are in February 2022. Yes. Now what is the state's notification has been issued? Yes. Now, how many applications you have received, government advocate?
Yes, and the age factor is considered. Whether the bylaw,
All that towards the total only to the other data is established. But then the agenda is towards the.
Kindly use the mic. Kindly use the mic.
The bylaws is concerned, there was a direction where it's supposed to reconsider. Should be the registrar and it is.
Karnataka?
Such as the section 9 and 10 is.
9 and 10 is where it is society situation. There is a provision for filing an appeal. That is by the institution with regard to the case.
And that is also concept to be challenged here in the connected data. How can we make it easy? That is what I'm saying.
Challenge is an order passed by defining the matter to the registrar to consider. As I said, registrar and now.
That is what I find for dismissal of here.
Chepi. No, which appeal deserves to be dismissed, no?
Thereafter, there are some notification for the registrar. Regarding the superannuation. I challenge before the dishonorable court is repeated.
Yes.
In that there is an interim order.
Yes.
If it needs multiple appointments made, there is no question. Interim orders. Now the appointment of the government director is concerned, notification is issued for eligible candidate file an application. Application is filed, even the appointment. The application is present. Immediately, the general body was heard. The court have taken some decision. That decision has been placed by the different institute. There is a honorable chief minister. Even before the government, that was highlighted in the 714.
No, if all of you make submissions like this, we cannot understand, sir. Kindly make submissions one by one. How can we hear?
That's why it is interference in the registrar. Also, before the government, and what is made is by the learners.
So according to you, you are still surviving.
Because no question, another single head not consider our objection in total.
Where is the order of the learned single judge here in 556? Whether it is arising out of the same order or different order? Yes. Continue at 230.
May I have leave to mention?
Yes. Normally, we are not allowing mentioning at this hour, sir. Yes.
Serial number 25, my lord. Kindly have it on next week, my lord.
That is the reason we are not allowing any mentioning at this hour.
Some inconvenience in afternoon, my lord.
No, it applies to everyone, learned senior counsel.
Then 2:30.
The reason we requested the learned senior counsel. If you sit here to hear you, all of you, it will be 2 o'clock by again. Yes.
Can we mention at 2:30?
Sir, sorry.
ಜನ ಮೇಂಟೈನ್ ಕೊಡೋದಿಲ್ಲ
Murray.